What is a mock trial competition?
A mock trial is a pretend court case where you have your barristers, your solicitors, you have a judge, and then you look at a set of facts and determine who's going to win. Typically, it's either a criminal case, prosecution and defence, or a civil case when you have basically an applicant and a defendant, essentially, usually arguing over money. But essentially, it's a pretend court case. It's a lot of fun.
Why should high school students get involved in mock trial competitions?
Because they are very good fun, and also they just test your mettle, they test your ability to think on your feet, and if you ever want to be a lawyer, it's a really good testing ground for you to get some sense of what it's like to be a practitioner.
What skills might students develop through a mock trial competition?
Well, there's always collaboration. You have to talk with each other about how you're going to manage your case. Of course, you have your two barristers, so you get some idea about speaking out loud. And particularly when a judge interrupts you, you've got to start thinking very carefully about how you're going to answer the questions. So there's some skills associated with debating with the judge. The judge will say, I think you're wrong, or I don't like that submission. And then you have to argue very politely, of course, that your submission is actually a very good one. So you get a little bit of banter, argumentative idea, but the other skills you have are thinking about how things are going to unfold. And then when they do unfold in a particular way, you're ready with the answers.
I don't want to be a lawyer. Should I still get involved?
Look, you should still get involved because they're good fun. You have a kind of a thinking competition. It's a bit of a debate, but it's an ongoing debate because people are interrupting all the time. So you have to think on your feet in that regard. Whether you're going to be a lawyer or not is irrelevant, because if you're going to be in business or any other sort of attribute of human life, the idea of standing up for yourself, being very polite and responding appropriately to a question and learning some articulation skills are very good skills you should learn for life generally, lawyer or not.
So what specific skills might a student need to participate in a mock trial?
Thinking skills, thinking on your feet skills, ability to bounce off others, ability to think strategically and to work collaboratively. Those are the sorts of things you learn when you're talking, particularly in planning something, getting 4 or 5 heads together to say, what are we going to argue here? What if they say that? How are we going to respond to that? So that sort of collaboration is good. And of course, you need to learn how to articulate, particularly to speak slowly and clearly in sentences that have a start and a finish.
Can you tell us what a mock trial looks like? So what is the procedure of a mock trial?
The procedure is just like being in a court case, although typically you're in a library room. So the judge sits behind a desk, and you and your partner will sit at another desk, and you'll be facing each other. And behind you, you'll have your solicitors who from time to time will think carefully about what your answers might want to be and prepare you for a question you might not have asked. So it's kind of like in a library room where you're in a bit of a circle and everyone's looking at each other, and behind you are the audience, and they're probably thinking, wow, this is going very, very well. It's good fun.
What is the role of each team member? So barristers, solicitors, witnesses, judge's associate, sheriff, and the mock trial judge.
Well, the judge is there to be the umpire, to make sure the questions are fair, and ultimately to make a decision about who wins that particular competition. Wins in terms of the law case, and wins in terms of the presentation. So there's always 2 answers at the end of the night. So the barristers do the working and the talking, and they work together. Typically one barrister will do the examination and cross-examination of one witness, and then the other barrister, the other witness. One barrister will open the case, one barrister will close the case. Behind you, you'll have 1 or 2 solicitors who won't say anything during the case, but they'll be making some notes, particularly ahead of the closing argument, when they'll work with you about what best things to say. And then you have a sheriff's officer who calls the court together, and you have a timing person who typically advises the judge about whether or not you've gone over time or under time.
Witnesses?
The witnesses are very, very important. You have to have students who are friends of yours who know exactly what their brief is, because they're going to get questioned by you about what happened on that particular occasion. they then have to be ready for the fact that the other barrister on the other side is going to try and find holes in the argument. So the witnesses have to hold up and not stumble, and that usually requires them having some practice ahead of the time with you trying to catch them up to make sure they stick to their story.
If it's my first time involved in a mock trial, what role should I take?
I would suggest if it's the first time and you're just a little uncertain about speaking out loud, work as a solicitor, which means you then get to start planning the way in which the whole thing's going to unfold, what the opening statement's going to be, what the closing statement's going to be particularly. If you would like to hear what your voice sounds like in a mock trial, become a witness. You then have to get right over the facts to know exactly what it is you're saying, how you're going to help your case, and how you're going to defend against someone trying to catch you up in relation to those facts. Once you've got a sense of what it's like to speak aloud, particularly as a witness, you then might want to try being one of the barristers. And that's always a lot of fun. And it also just tests you, particularly when the judge stops you and says, now wait a minute, I'm not so sure that was a very good question, or there's an objection from the other side saying, I object to that particular question. You have to think on your feet about why it is you're going to try and overcome the objection and convince the judge to allow that question to go ahead. So that's the toughest part of a mock trial. If you're a little nervous about it, solicitor first, then witness, then barrister. But everyone should have a go at some point in being one of the barristers.
I just got a case. What is the first thing I should do with my team?
The first thing you should do is read the whole thing together, right from the beginning and right from the end. Don't stop halfway through and start thinking about what your arguments are going to be. Make sure you've got the whole factual situation ahead of you. Look at the precedents. See then how you might want to think about arguing it, and then have your first meeting essentially about what your argument is going to be and how you're going to construct your case. But my advice would be to look at the whole thing first before you start picking holes in it.
I've been appointed as Barrister 1 for the defence or respondent, civil or criminal. How do I prepare for the opening?
If you're Barrister 1 preparing for the opening, I would start writing it out straight away, because ultimately you have to tell the judge what your argument's going to be, plus you have to tell the judge what your witnesses are going to say. And that essentially would be you preparing the whole position right at the outset. Keep it nice and short. There's a time limit associated with that. And then once you've written that out, discuss it with the other members of the team to make sure you've covered everything. And importantly, articulate it. Actually do the opening aloud to your friends before you actually go in and do it before the judge, because you have to practice what it is you're saying, and particularly learn by taking cues from your lines to have some eye contact with the judge. The last thing the judge wants to see is someone whose eyes are buried in the words in front of them. Articulate with eye contact with the judge. Look down, get your next line, practice it, and then deliver the rest of it after you've said the first few words to the judge with eye contact.
What is involved in the examination in chief?
The examination in chief is when you take your witness. Now, if you're the first barrister, it'll be your first witness. If you're the second barrister, it'll be the second witness. And essentially what you do is you're asking in very broad questions to ask the witness, whether it's a person who saw a crime being committed, or whether it's a person who has lost money and is trying to get the money back in a civil trial, what actually happened? Tell us in your own words what happened on that day, and allow the witness, who's done some schooling about what their facts are supposed to be, to tell the story, because you're not allowed to lead them. You can't say, so when you saw the ball fall out of the sky, and they haven't mentioned the ball, you can't do that. There'll be an objection to that. So I understand something happened on that day. What happened on that day? And they'll tell you about the ball falling out of the sky or whatever. So you have to learn to get the story out of your witness without leading the witness. The witness has to tell his or her tale on their own. And that's a pretty straightforward exercise, because if you're not leading, there can't be too many objections to that. Most objections start when you're doing cross-examination, but you'll have a practice with your witness to get them to tell their story in a way that makes their case very persuasive.
So talking about objections, how do objections work in the courtroom, and how do the barristers manage them?
I always advise the barrister on the other side of the mock trial to try and get at least 2 objections, but not too many objections, 2 or 3 objections per witness. And particularly, you're protecting your witness when he or she is undergoing cross-examination from the other side. So if you hear something which is actually trying to ask the witness a question that's really multi-leveled, you'll object and say, Your Honour, that question's just 5 questions there. My client certainly can't answer that because we just don't know where that question's going. Or there might be an objection on relevance, or might be an objection on hearsay. There's a lot of things we can talk about in relation to objections, and they're very important. But when I've been a judge, I sometimes get tired if there's too many objections, particularly if they're not very good objections. I think you should always be prepared to make 2 at least objections, maybe 3, during any examination of a witness, either an examination chief or a cross-examination. But of course, when you do make the objection, the judge is going to say, what's your objection? At which point you then have to defend your objection. So make sure you don't have an objection unless you know what your argument's going to be. If the judge overrules your objection and says there's no objection there, the next thing you say is, as it please your honour, or if it pleases your honour, because you're very polite, of course, and you'll accept the judge's ruling and go on with the next question.
And what is the purpose of cross-examination?
The purpose of cross-examination is to make sure that the witness is not telling fibs. You're going to try and catch the witness out. If they've made a particular observation about what they saw, your cross-examination is, tell us about the light on that night. It apparently was 10 o'clock at night. The light wasn't very good, was it? Oh, it was very good, says the witness. Well, how far away were you? You said you were quite close. I put it to you, in fact, you were 150 metres away. Oh, well, I might have been 150 metres away, but I've got good eyesight. You're wearing glasses today. Were you wearing glasses on the night? In other words, what you're trying to do is to get under the witness's testimony and try and kind of find out the way in which the story might not be as clear as when they were giving evidence in chief might have made it out to be. So the idea of a cross-examination is to put holes into the witness's evidence.
I've heard for a barrister, cross-examination is hard. How can I get it right?
You get it right by practice. And of course, you won't get it right the first time you do a mock trial. Some of the best barristers in legal terms are ones who've been doing this for 4 or 5 or 6 years. The first few trials you do, you might find a bit more difficult. What I would do in those circumstances is essentially put one of your friends into the role of being a witness for the other side and practice your cross-examination with them. And you'll get more confidence the more you do.
I've been assigned to the role of barrister 2 for the prosecution or plaintiff. How do I prepare for the closing statement?
Well, the way to prepare for the closing statement is to write it out as if you were actually in the trial. In other words, prepare ahead of time what it is you're going to be saying, because you know exactly where your argument's going. And so, in fact, you'll prepare 2/3 of it in terms of writing it out and practicing it. And of course, as I said, make sure you've got some eye contact with the judge in delivering it. But I want to make this point very clear, that your solicitors are thinking all the time to make sure that they are hearing things, particularly from the witnesses that you've cross-examined, that have highlighted the fact that in fact there could have been some weakness in their argument. I always say the best closing arguments are ones that have picked up on something that happened in that mock trial, because the judge is looking to try and make sure that you just didn't prepare the whole closing argument before the case. You've practiced it and it comes out as if you've written it 3 weeks ago. What really impresses a judge is when your closing argument picks up on something where someone stumbled during the course of the trial. Your solicitor's looking out for that, and when you have your little 5 minutes between the end of the witness statements and the end of all the examinations of witnesses, you've got 5 or 10 minutes to get your final closing statements ready. During that time, I would add little bits and pieces to your closing statement that pick up on the weaknesses that emerged during the trial. Judges like that.
How should I speak to the judge? How should I address the judge?
You address the judge by using the phrase, Your Honour. If it pleases Your Honour, as Your Honour says, as Your Honour pleases. You're always very polite, but whenever you're referring to the judge, it's always Your Honour. And you might want to talk about other judges who've made judgments you're referring to as His Honour or Her Honour. The word honour comes out a lot in court cases. Always make sure that you're being very polite and courteous to the judge. Never say, I think Your Honour is wrong on that, or I disagree, or make a kind of a sour face. No, you've always got to be very, very polite to the judge.
And further to that, what is court etiquette and what does this mean for each of the team members?
Court etiquette is basically only speaking when you're standing, and if you're not speaking and not being addressed by the judge, you sit down. You'll have to practice that. If you want to make an objection, you stand up, and the court etiquette typically is if another person is addressing the judge, the other side actually sits down. So only the person who's being addressed by the judge is on their feet. The other court etiquette is, of course, when the judge comes in and the judge sits down, or as the judge is sitting down, there will be some bowing. If you leave the court for any reason, you'll bow as you go. So court etiquette is very, very good, and make sure you actually play the game in that regard. Judges are looking to make sure you're not taking a cavalier attitude to the exercise. You are pretending you're in an actual court.
As the judge yourself, watching everything going on in the courtroom, what are some things you see teams or individuals do that impact on the outcome of their case, or things that you would like them to stop doing?
I tell you what I do like them doing, and that is conferring with each other, because this is a team sport, a team game. It's not something that someone just makes up on their own. So I think in those circumstances, I like it when the solicitor is being involved and there is some good discussion going on between the teams. In terms of what I don't like, I think that the judges' roles that I've had over the years, I've always seen teams act appropriately. I do like the court etiquette. I like it when they stand up if I'm speaking to them. I like it when they sit down when I'm not speaking to them. If they lose that etiquette, I start thinking they really haven't practiced this particularly well. But my general view of people who actually do involve themselves in mock trials is very, very good. I like the way in which they take them seriously. That's important.
So what are some big mistakes students make in a mock trial, and how could they avoid them?
The first mistake is when the judge asks for appearances. The judge will typically say, I'll take appearances now. Now, at that particular point, the first barrister for the applicant or the prosecution will stand up and say, if it pleases the court, Your Honour, that's part of the etiquette, that's your opening statement. If it pleases Your Honour, or if it pleases the court, Your Honour, my name is Jones, and I'm here with my learned junior, Smith, for the prosecution. Only use the surname. Don't use your first name. And don't say, good morning, Your Honour. No, none of that nicety. That's all you have to say. If it pleases the court, Your Honour, my name is Jones. I appear with my learned junior, Smith, for the prosecution. Sit down. Now, in those circumstances, that's the etiquette. Don't start going on about what a lovely day it is, or it's a perfect day to win a case, Your Honour. No, don't try any of that at all. That's your appearances. That's kind of part of the thing that I like, part of the way in which you are well prepared, at which point, having you sat down, the other side stands up and does exactly the same. And then the judge will say, I'll have your opening statement, Ms. Jones. And Ms. Jones will stand up again and leap straight into what it is she's going to say. Just watch a couple of mock trials, particularly go along perhaps and see some finals to see the finalists who are now doing that very, very well, and model yourself on that.
Are there any mistakes when a barrister is examining or cross-examining a witness that you've noticed?
The main one that I see, which is infuriating for a judge, and one that actually gives rise to a very good objection from the other side, is when you're kind of making the questions up as you go along, which I rather like. It means you're not particularly formulaic and you haven't practiced this thing. You're going to ask the questions ahead of time anyway. But you kind of think, I can try and catch this particular person out, and you have a question that involves 4 or 5 things. So what I'm thinking is that you're doing this, and then you did this, and so what you were thinking was this, and when you acted this way, and the question goes on and on and on, and the objection suddenly is, Your Honour, My witness can't answer that question. Which question would you like them to answer? It's a ridiculous thing. So one of the things that I would be very cautious about is when you are asking questions, particularly in cross-examination or of your own witness, short, sharp and shiny. What happened then? I put it to you that you didn't say that. Short. I put it to you in cross-examination. I put it to you that you saw nothing at all. Full stop. In other words, in those circumstances, keep your questions nice and short. Don't have double-barreled questions.
You have done in the past when coaching teams a rule of three, so in a cross-examination when you're trying to really nail a point. Could you give us an example where you could do the 3 questions and nail a point?
Yeah, I like the nailing of the point. I particularly like the nailing of the point when you're preparing this, and typically you would prepare this ahead of time. Don't try and do this on the fly, because it has to be exact, because there's a bit of theatre associated with this. And I've seen this very, very effectively in relation to some teams. They do it very well, but they have to practice it. I like a flourish at the end of the cross-examination with 3 questions. So you've been cross-examining for 5 or 10 minutes. The witness is hanging on to their story. They're saying things that you don't think are actually exactly what they should be saying. Let's say it's a criminal case and you've got the person who's defending themselves saying, I really didn't do it, I was thinking something else, and they're trying to defend themselves. And you're the prosecution, for example, and you're now cross-examining the witness for the defence, who is the defendant, who is saying that she simply wasn't as bad as it always made out to be in relation to this criminal charge. Finish your cross-examination with 3 quick questions and prepare those ahead of time. You'll get 3 denials, but that's okay. You're making sure that the point is being made that you actually don't believe anything she said. So you'll have 3 questions. I put it to you that on that particular day, you were driving an unregistered car. No. I put it to you that you were driving far too fast. No. I put it to you that when you drove that car far too fast, you hit the pedestrian and had no compunction about driving off. I deny that. No more questions, Your Honour. Boom, boom, boom. Get those last 3 questions out. A bit of theatre, a bit of drama, but you've actually made it abundantly clear to the whole court you don't believe a word she's saying.
How do you start with developing a case theory? So you've got the case, you want to develop what your case theory is. Can you explain how to do that?
The case theory is essentially the main underpinning point of the whole case. Let's say it's a negligence case. You left your gate open and the dog raced out and bit the person who was riding their bicycle. That's actually one of the cases we've had in the past. And the person's fallen off their bike and been injured. So if you're the plaintiff, you're the applicant, you're going to be saying that this was terribly negligent and the gate was left open. So the whole case theory is based upon negligence, that the person who you want to get some money out of now was completely negligent in allowing this to happen. And the whole case theory is that you, as the applicant, are trying to get some money for something that should never have happened, and you now want some compensation. So every aspect of everything you say in terms of the witnesses comes back to that one point: this person's at fault, this person was the victim, this person was at fault, this person was the victim. And so every aspect of what you're doing is based on that. Your opening address talks about that. Your closing address talks about that. Your cross-examination talks about that. If, of course, it's, say, a criminal case and you're defending someone who's been charged with an offence, the whole case theory would be this is a complete mistake. It was never intended to happen this way. There was no malice aforethought in your client. Your client is as pure as the driven snow. And every time you've located that particular case theory of saying beyond reasonable doubt this person could not possibly have been found guilty, you are thinking and lining up every question, every opening statement, every closing statement on that particular one point. And you'll be driving that point home through every question you ask, whether it's an examination in chief or cross-examination.
Okay, so to finish, what are your 3 top tips for success in a mock trial?
The 3 top tips. Number 1, try as far as possible to have eye contact with the judge. Don't look like you're buried in your notes, because that could simply mean that you are too involved in what it is that you've pre-prepared, and you're too nervous about going outside of that and thinking on your feet. Judges love to think that you've actually been doing some thinking during the court case. Number 2 would essentially be make sure that your etiquette is absolutely spot on. You know exactly what to say, when to say it. And so when you've got your objections, they're either good objections, or if you make an objection that's overruled, your etiquette is to say, as Your Honour pleases, and get on with it straight away. The idea of being very, very helpful to the court, to make it abundantly clear that you are there to help the court, will advance your case as well. And the third one, and the one which I still think is the most important one, make sure your closing address draws upon things that have come out of the court case in that particular occasion. You might want to say, Your Honour will recall when the witness for the other side was asked this particular question, he hesitated and said this, this and this. And that might not have been exactly in the way in which it was actually presented in the sheet you got on the paper to say, here's your mock trial tonight. But you can say, when he hesitated in relation to that, it highlighted, Your Honour, that he's unsure about that particular point. And if he's unsure about that particular point, our submission is he was completely unsure about this point, this point, this point, and this point. I would put to Your Honour that that particular witness and what they were saying was fabricated and in the circumstances should not be relied upon. In other words, your solicitor's listening all the time to what's going on in that particular case, and you've incorporated that into your closing statement. I'll tell you, in a lot of the judgments I have made, that has been the crucial point from 2 very keenly fighting parties, to have me find that in the ability of that particular team on that particular night, they picked up on something that emerged during the case, not something they'd thought of prior to coming into it that night.